session. The Honorable James A. Edwards, Judge presiding. All persons having business before this court draw near. Give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to a session of oral arguments. And we have great events today. As our marshal said, I'm Judge Jim Edwards. To my left is Judge Scott Makar, formerly of the First District Court and now a firmly ensconced member of our court. This is his first in-person oral argument at the court. And to my right is Judge Carrie Evander. And I hate to report that this is his last day of oral arguments here at the court because he's going to be leaving us at the end of February. And we thank him for all his service at all levels of the court that he's been. So, with all the announcements out of the way, our first case today is 21-3137, Baker Family Chiropractic versus Liberty Mutual. Each side will have 20 minutes. Typically, we go with 5 minutes rebuttal. If you want anything different, just let us know, and we'll be happy to change that around. I know y'all are experienced at this, but sometimes people get a little confused. You do have a clock on the podium. There are lights. When it gets to yellow for the appellant, you're into your rebuttal time. The amount on the clock that's shown, that's it. There's not like an extra 5 minutes hanging around somewhere. So sometimes people get a little confused. We don't want to have that happen. If you've got anything that might make noise like a telephone, put it on vibrate or silent, or go crazy and turn it all the way off. But with that, we're ready to proceed, counsel.
Thank you, Your Honors, and it is a pleasure to argue in front of Judge Makar for your first time here. Glad that you're here, and Judge Evander, we will miss you. My name is William England, and if it pleases the court, I would like to reserve 4 minutes for rebuttal.
All right.
Here we have an issue with regards to entitlement and interpretation of Florida Statute 627.428. There are three independent reasons why the trial court should be reversed. Specifically, the first one is purely contractual interpretation. Under 428, plaintiff prevailed in the underlying action, enforced the terms of the insurance policy, obtained insurance proceeds in the form of additional interest owed under the contract of insurance. This is separate and independent from the no-fault statute. The second basis is the trial court misinterpreted and misapplied the no-fault statute and erroneously relied upon the fourth DCA, which was clearly distinguishable, and we will address. The third basis is the trial court, upon this the initial appeal being dismissed, misinterpreted and misapplied the mandate of this court. Specifically,
let me ask about that issue. The trial judge had awarded fees but had not determined the amount.
that is correct.
Therefore, it would appear that we would have no jurisdiction to even address the issue of whether there was entitlement. So I'm not sure how we could have agreed with the judge on entitlement or disagreed with the judge on entitlement since we lack jurisdiction. So how would that create a mandate or law of the case?
Upon the mandate from the initial dismissal of the initial appeal, this court granted our motion for appellate attorney's fees condition upon it going back down to the trial level and the trial level determining entitlement for the appeal. That was the clear language of the order of dismissal, adopting the Liberty Mutual's dismissal of the initial appeal. And so the trial court, which was a secondary judge rotated in, interpreted that as you want them to interpret everything, to go back. So she interpreted that.
I think what Judge Evander was saying, and what seems clear to me, the issue of entitlement of attorney's fees was not a final order after the first case in terms of appellate review.
Yes, sure.
So it could not have come up to our court for review. If somebody had tried to raise that and argue that, we would have said it's premature. We don't look at entitlement without an amount. If it's not a final order, it kind of sounds like it's an interlocutory order that might be revisited, and a suggestion you might want to spend your time on other issues.
Absolutely, Your Honor. I appreciate that. So with regards to the facts of this case, and I understand you know the facts very well, there's just important aspects I think we all should understand that are indisputable and would result in the law of the case, specifically that the initial final judgment found that plaintiff was enforcing the terms of the policy, that the policy required prompt payment of PIP benefits, that failure to do so would include interest. The policy did not specify an interest rate, so therefore the court looked to Florida Statute 687.01, which sets forth that when an interest rate is not specified within a contract of insurance, you go with Florida Statute 5503 in order to interpret that. That is purely contractual. We enforce the terms of the policy, and that's going to be important because your sister court in the 4th DCA stated that when they provided their analysis in 2022 on a similar matter, while this was pending up on appeal, they clearly specified that the court's review was limited just to statute in that aspect, and that was in Liberty Mutual Insurance Company versus Pan Am Diagnostic. And specifically, the 4th DCA stated that we're under de novo review, but we're looking at 428, which means we have to apply the clear language of the statute. The clear language of the statute says that when an insured or an assignee of the insured is forced to file suit in order to enforce the terms of the policy, and they prevail, they get a judgment or decree, the court shall award fees and costs. However, in the Liberty Mutual case in Pan Am Diagnostic in the 4th DCA went on to state that the provider has not shown that there is an entitlement to interest on the late payment of PIP benefits grounded upon any policy or contractual provision. Right?
That's not our case, is it?
That is not our case. That is apples
The
and...
stipulation of the parties before the first trial was the sole issue for the court to resolve is whether the interest due and paid on 4/22/2019 was correct and proper under the policy of insurance in Florida law, right?
Absolutely.
And then throughout the judgment, the first judgment, the trial judge talks about contract and policy and concludes ultimately that under 3 separate statutes and the policy, it was not correctly paid, right?
Exactly, Your Honor.
And so it was, that was an issue that was decided. That was an issue that was appealable. It was appealed, and Liberty Mutual dismissed the appeal, correct?
That is correct, Your Honor.
Okay, so that could be law of the case.
That is exactly what our position is, because upon remand, after the dismissal of the appeal, the subsequent judge, in their analysis and their denial of entitlement, focused solely on statutory entitlement, focused solely on the no-fault statute, and completely ignored the law of the case when it comes to the fact that we correctly, properly, and lawfully enforce the terms of the policy.
And let me ask you about the statutes. Under 627, 736, there are like 2 30-day safe harbor times. If the claim is due, meaning the benefit is due within 30 days of receipt of the initial submission of the claim to the insurer, correct?
Yes, Your Honor.
All right. If they pay it then, everything's fine. If they don't pay it then, once it's overdue, the insured or the assignee in this case can send a demand letter, which was done in this case,
Yes, Your
saying you're $168 short. If they pay everything, again, within the 30 days provided by statute, you can't sue them at all for anything, correct?
You cannot, or at the very least, you would not be entitled to fees.
Well, if they pay everything, you can't sue them for anything.
Yes, Your Honor.
If they pay the attorneys, if they pay the claim, and claim is separate from interest, penalties, and postage, if they pay the claim within that 30 days, you're not entitled to attorney's fees, correct?
That is correct, Your Honor.
Okay, and that's where we are here. They didn't pay within the they short paid the $168. A demand letter was sent out saying you owe us $168 plus unspecified interest. They didn't pay within the 30 days, did they?
No, they waited 41 days.
So they're not within the safe harbor provision that's provided by 10D, correct?
That is absolutely correct, and that takes me on to my second point, which was the trial court incorrectly interpreted and misapplied the no-fault statute.
Well, before you get to that point,
Yes, Your Honor.
so the 168, there's a demand letter says you're late, 168 plus interest. So they paid the 168 plus some amount of interest.
They did.
All right. And whether they calculated right or wrong, that's been determined, but let's say they paid $6 and it should have been $7.50. Is there anything in the record that before you filed suit for the $1.48 that there was a demand saying you miscalculated by $1.48?
The record reflects the demand letter, the record reflects the untimely payment, and it also includes the stipulation of the parties that narrowed the issue solely to whether or not the insurer properly paid interest owed under the policy and the statute. So by narrowing that legal issue down to that one statement, the Liberty has waived the argument as to needing a supplemental demand. And there's no statutory basis to send a second demand or send more than one. They already had 2 bites at the apple. And that's the reason why the statute holds that way and is phrased that
All
way.
right, so the answer to my question is no?
No,
There's
Your
nothing
Honor.
in the record?
No, there's nothing on the record other than the waiver of that argument by Liberty at the trial level.
Do you think we should encourage that type of action by lawyers where you have $1 in dispute, $1.48, and instead of saying you're $1 short, you just file suit?
Your Honor, the purpose, it's not encouraging greedy lawyers. I respectfully submit that it's not encouraging greedy lawyers, that the
Well, if you had
purpose-
sent the demand letter and they paid, we wouldn't be here, right? Or maybe we would, I don't know.
Yes, and understanding that when we sent the bill, they had a chance, like Judge Edwards hit on.
Right,
They had
but they calculated the interest wrong.
They did, and entitlement, oh, I'm sorry, Your Honor.
What if they were a penny off, and you didn't ask for the penny? The same result, right?
If we did not ask for it, yes. However, in this particular aspect, our demand letter did ask that they calculate the interest pursuant to 5503, which is the statutory basis. And the reason why we could not specify an interest rate is because
You don't know exactly what day they're going to pay it.
exactly, you
Right.
know, if they had paid 30 days after, but we only calculated for 20 days, then the demand letter could arguably be inaccurate.
But under your argument, if they calculated that it was $6.01 and it should have been $6.02, you could immediately file suit and seek attorney's fees.
As long as they do not pay within the 30 days or announce that they're going to pay in full within 30 days, if it's an instance like this where they waited 41 after the second bite at the apple, then yes, they have breached the policy if their policy requires them to pay the interest.
Right, and so they've paid it late. They've responded to your demand letter by paying the $168 and by paying interest, but if they're a penny off on the calculation, it's your position that you could then immediately sue and seek attorney's fees.
I always try not to immediately sue, but yes, arguably under the law, that could happen.
Let me ask you this, counsel. Under 627, 736, 10A, which is the demand letter provision, it says as a condition preceding to filing any action for benefits under this section, you must make a demand.
Yes.
Is interest truly a benefit?
Interest is a contractual proceed. So this is where we get into the second prong of the argument where the court,
If you look at what the fourth DCA did, they broke down benefits as health care, disability, and others. I know it was lost wages, but or death benefit, I guess. There's 3 distinct benefits. Interest is something other than the benefit or the overdue claim, isn't it?
I don't believe it is, because with the swift and
It's
virtual.
not. If it is a benefit, then you had to send a demand letter. If it's not a benefit, then you're okay, right?
That is correct, Your Honor. And so when looking at it, and the fourth DCA's analysis, when they were looking at subsection 8, which states that 428 and the offer of judgment statute apply to any dispute between Florida Statute 627730 and 6277405. They then went to 731 to look at the purpose of the statute, which is what your question is hitting on. However, where it's our position that the fourth erred is that it improperly nullified subparagraph 8. It added limitation language where the legislature did not draft limitation language. And explicitly, under subparagraph 8, it looks to any dispute, any, that is clear language. And what is within that range? Subsection 4D of the no-fault statute. Subsection 4D does include interest. So if you look at the plain language of the statute saying it applies to any dispute, and 4D falls within that range of where it applies, then to say that it only applies to benefits or specifically labeled benefits is erroneously limiting the language of the statute, which the legislature knew what they were writing, and they chose not to put that limitation in. They only added 2 exceptions: the subparagraph 15, which is res judicata, which does not apply here, and subparagraph 10, which Your Honor was hitting on, where if they pay within 30 days or state that they're going to pay in full within 30 days, then you cannot sue them. So there's only 2 exceptions that are clearly delineated within subparagraph 8, and the 4th added another. That is where we hold, or we are asking this court to reverse the trial court on, because the trial court, upon going back down, relied upon that limitation.
In the first trial, Liberty Mutual didn't say, oops, our bad, we underpaid you a penny. They fought it. They litigated it, correct?
They did.
And then after that, after they lost at trial, they then took it up on appeal to the point of they filed their initial brief, you filed your answer brief, and then they dismissed the appeal.
Absolutely.
So this was not, sorry we made a mistake, and I understand that sorry we made a mistake could have a $30,000, $40,000, $50,000 price tag with it, but we've got to interpret the statute as it's written, don't we?
Exactly as it's written. Which
Can
is
we
also,
tell from the record whether they were contesting the $1.48 or whether they were contesting the $1.48 plus attorney's fees?
they were disputing both. They argued that there was a flat interest rate calculation under 4D, and instead of going with the annualized interest rate set forth under 5503.
But if they were successful on that, then they wouldn't have to argue about attorney's fees. But
If they were successful, then they would not have had to argue attorney's fees.
is there
because-
anything in the record that suggests that they wouldn't have paid the $1.48 willingly, but for the demand for attorney's fees, or is that just a question that's not clear from the record?
That is not clear from the record. However, as the trial attorney, I did have communication with.
If it's not in the record,
Okay.
don't.
So it's not on the record, but I can tell you, I can reassure you, they wanted to fight over the interest. And then when it went up on appeal.
Well, if it's not in the record, you cannot argue it.
They did fight.
They did fight over the interest, and that's why we went to summary judgment, that's why we
But we
stipulated.
can't tell if they were fighting over the interest because of the attorney's fee assessment that may or may not follow afterwards.
Oh, yes, we cannot defer or interpret their
Right.
motivations
Right.
From the record. However, what we can see is that in this aspect, the insurer chose to litigate, the insurer chose to fight, the insurer chose to not pay the bill in full within the first 30 days. They were given a second bite at the apple. They chose not to comply with the statute. They violated the condition precedent that would have protected them under subparagraph 10. And then they chose to litigate, stipulate the facts, go to summary judgment, take the appeal, and then in their initial appeal brief, they argued solely the statute, that the statute, statutory application of interest was incorrect. In our answer brief, we highlighted again, our argument was contract and statute, both. We went under either prong. And then once we filed our answer brief, that is when they dismissed the initial appeal.
And the appeal, the initial appeal was all about the interest rate.
It was.
It was not about attorney's fees, was it?
It was not. In fact, there was a footnote by Liberty that said they cannot appeal the entitlement to fees until there's a dollar amount, and so they were waiting to see how the court ruled on the interest before they dismissed the initial appeal. And so 428, I see that I'm falling into my rebuttal time, so I'll wrap it
Wait
up
and
pretty
say.
quick.
Okay,
Yes.
that's fine.
428 was clear that it applies when an insurer makes a mistake. There's nothing malicious about it. It's when you mess up and you choose to fight. 428 is what levels the playing field between the large insurance carrier and the assignees or the insureds.
So it says Fred Lewis, right?
Yes, Your Honor.
Okay,
I'll save the rest of my time for rebuttal.
all right.
Good morning, Hinda Klein here on behalf of Liberty Mutual. We believe that the trial court correctly found no entitlement to attorney's fees under the facts of this case. 627-428, which is really the only attorney's fee statute that actually grants an entitlement to fees, requires that upon rendition of a judgment against an insurer and in favor of a named or omnibus insured under a policy or contract executed by the insurer, then the trial court shall award attorney's fees. We submit that that language under a policy or contract executed by an insurer is not just excess verbiage. It requires that there be a recovery under the insurance policy.
In the first trial, didn't the judge look at the stipulation and see that the only issue is whether the interest was properly paid under the policy of insurance and Florida law, and then in its judgment find that it was not properly calculated under 3 different statutes and the policy?
Well, I don't think there's any question here that the policy makes no mention whatsoever of insurance.
Question to you was not that, was it?
I understand.
My question to you was, isn't that what the judge did?
Respectfully, I don't think that if you look at the judge's final summary judgment, that is what the court actually concludes. The court goes on and on for, 6 pages about what the actual issue was,
What's
which
the
is...
final decision, though? Doesn't it say it's under 3 different statutes and the policy, it was not correctly calculated?
Correct.
Okay?
That
So you had
is-
a judgment that said this was due under the policy and these statutes, right?
Correct, yes.
Y'all appealed it. You could have contested that finding on appeal. You dismissed the appeal.
We dismiss...
So that finding is bulletproof, isn't it?
Respectfully, I don't think so, because...
Why not?
Well, first of all, we dismissed the appeal because at the time all of this was going on, there was a question of law as to how to calculate interest under the PIP statute. And during the pendency of the appeal, that issue was finally addressed.
Well, in
And
your
there-
brief, you say you dismissed it for reasons that aren't relevant, so
That's...
are they now relevant?
No, Your Honor. I was just trying to respond to your question. That comment, and that's what I think it was in the final summary judgment on this about under a policy or contract of insurance, is basically not a finding that there was anything in the 4 corners of the policy that referenced interest, excuse me. It simply...
Right, and the trial judge, the first trial judge could have been wrong. But the first trial judge said the court finds that plaintiff is owed $1.48 in prejudgment interest pursuant to 627-736-4D, 55.03, 687.01, and the policy of insurance for which let execution issue. That was her judgment, the court's judgment, which y'all appealed and then dismissed the appeal. So it's there forever in rock in that case. It may not have been a correct decision. Don't get me wrong. I'm not saying that that was necessarily correct, but that's what you have to live with in this case, don't you?
Except that what I think that the court was referring to is the fact that the policy, like the statute, talks in terms of payment being overdue if not paid within 30 days. It is only the PIP statute that talks in terms of what the penalty is, which is interest. The court does not refer to any section of the policy as giving rise to an entitlement to interest. It's not there.
I agree with you. I've read the policy. I had my clerk look and see if it specifically said. All it says is it's overdue after 30 days.
Right.
I totally agree with you. But the judgment you had puts it under the policy. May be wrong. I mean, a lot of times, if judges always got everything right at the trial court level, we'd be doing something else because we would have no need to be here. They don't always get it right. If they don't get it right, your right is to take an appeal and challenge their finding. You did that, but then you dismissed it before you let this court make that decision. So that decision is made for us, I think.
Well, but here's the question, is that if we had taken it up on appeal and determined, hypothetically only, that there were not legitimate grounds to argue the ultimate decision that the judge reached, which is that you have to calculate interest on overdue benefits changing annually. That was the be-end and end-all of this case. If we had decided, again, hypothetically, that that was not a legitimate ground for appeal and that it would have been frivolous, then how would it have made any sense for us to appeal the one line or the judge's conclusion that that was under a policy or contract of insurance? It wouldn't have changed anything whatsoever.
Well,
It
but
wouldn't have
under the Fourth-
operated to reverse the
Under some of
judge's
the Fourth
ruling.
District's cases, though, they look at whether a benefit's been paid under the policy or just under the statute. So at least the Fourth DCA in one case thinks that's a big deal when you can't show it was under the contract. This judgment says it was under the contract. I mean, we can move, we don't have to spend all your time here on this one point, but
No,
But if the final judgment had said, the court finds that the plaintiff is owed $1.48 in prejudgment interest pursuant to Florida Statute 5503 and stopped there, this would be a non-issue.
correct.
So the question is whether adding the other language, whether that created a law of the case, if you would.
And I agree with the court, and that, I guess, was the point I was sort of trying to make. That was
And the law of
the
the case
basis.
requires a determination that that particular language was necessary to the decision.
Right, and I think that if this court had rendered this decision, I would argue that that language was not the thrust of the case and was not the holding. And I think that was essentially what happened here. There would have been nothing to be gained and no legitimate argument to be raised that that language was an error, but we're not going to contest the 5503 conclusion of the court. There was nothing, literally nothing to appeal, if not the 5503. So we were sort of in a bind. I mean, do you go up because you think that maybe, you know, they might raise that argument to say law of the case in a subsequent argument over the attorney's fees, which at the time was not ripe for appeal? There was no way to have this changed, and frankly, no reason to have it changed before this case or this issue came up for appeal. And I think...
Counsel, could I ask you to clarify? On that dismissal, did I just hear you say that there was no jurisdiction? Or you said...
No, we didn't believe that there was a justiciable issue after the appellate courts had determined how to calculate interest under 5503 and PIP cases.
Yeah, I'm trying to focus in on the dismissal of the earlier appeal.
Oh.
Whether that's somehow establishes the law of the case.
I understand.
Did this court actually have jurisdiction to hear that appeal?
Oh, absolutely it did.
Okay, so when
But
you-
it wouldn't have had jurisdiction to hear any argument about entitlement to attorney's fees.
Right, but it was about the interest.
Correct.
Right, okay.
Right.
Because in my mind I had this concept that maybe that was an entitlement judgment versus amount, and that typically you have to have the two at the same time, but...
Correct. And that's how we got here now. Was
you guys weren't appealing the entitlement question from the first trial, correct?
correct. We couldn't have.
Right.
We couldn't have. And that would have been the appropriate time, I think, to, I guess, raise the issue about whether this arose out of a policy or contract, but we couldn't have done it.
Well,
So-
maybe if Liberty Mutual versus Pan Am had been around, in which the Fourth DCA said, however, the provider has not shown that its entitlement to interest on the late payment of PIP's benefits is grounded upon any policy or contractual provision. If you'd known that was coming, that might have affected the decision, because, you know, who knows what a decision is going to be based on, but now that that's out there, whether it's under the policy or just statute, at least if you were in the Fourth DCA, it would be kind of a big deal, wouldn't it?
That's true.
Okay. Under 620, I'm sorry.
No, go ahead.
Under 627, 736, 10, you have two different ways for a safe harbor, if you will, a grace period. If you pay everything within the 30 days, you can't be sued for anything. If you pay the claim, which would be the overdue benefit, you can't be sued for attorney's fees but it has to be paid within the 30 days after the demand letter, correct?
Correct.
And there's no other safe harbor in 736, correct?
Correct.
Okay. And
Right.
what is unclear about the language, any dispute?
Well, there's nothing, it's not so much unclear, it's that 627736 does not give rise to an independent basis for attorney's fees. It simply says that you can seek fees under 627428, under the terms of that. And you necessarily then have to be entitled to attorney's fees under 428 in order to be awarded them. And 428 requires that the litigation be over a policy or contract.
And that's what the trial judge said in the first order, first judgment, that the interest was owed pursuant to 3 statutes and the contract, the policy, right?
Correct, but did not say where in the policy, and as I read it, I honestly think, Judge, that she was referring to the fact that they're overdue and subject to interest under the 30-day provision that is in the policy. That's the only thing that's in the policy.
Right, and I'll just do the 2-second, and you could have appealed that. You didn't. You dismissed it. You could have said, there's nothing in the policy that requires that you got that wrong.
Right, but then it wouldn't have been grounds for reversal of the 5503 judgment, which is the only judgment that would have been before the court. There would have been no point in appealing something saying we don't want a reversal, but we want you to correct this excess language that the trial court included in there. It wouldn't have made any sense.
Except under 428, if the recovery is based upon the policy, which the trial judge here said it was in part, then under 428 and 73610, the insured or the assignee is entitled to fees.
Except that that portion of the judgment that addressed entitlement was non-final and was subject to being reconsidered, which is ultimately what
I
happened.
agree, but the finding that the court finds plaintiff is owed $1.48 pursuant to the 3 statutes and the policy of insurance brings you into 428, doesn't it?
I hesitate to repeat myself, but then if we weren't contesting $1.48, if we were not contesting 5503 and how to calculate to $1.48,
But if the real
what would
boogeyman
we have
that you were
appealed?
really fighting against was against attorney's fees, it would have been worth your while to say, we're not under 428.
And if we had come before the court and said, we don't want a reversal, we just want you to fix this, would the court have done that? Would there have been any purpose to it other than a hypothetical argument that might be made in the future that this excess verbiage might be deemed law of the case insofar as whether or not the interest was chargeable under the policy or contract? It really was an untenable situation, and certainly I think that had we done that, the court may very well have thrown us out of court, because there's no point in appealing something when you don't want a reversal.
So if you had shown up for oral argument in that first case, and we said, what about 5503, and you said, yeah, it applies, that'd be a basis to affirm right then and there without even consideration of the other issue.
This court wouldn't have done anything different. It still would have been law of the case, and nothing would have changed. So it really was kind of a hollow argument to say, well, you could have appealed it, but you didn't. It's a little bit more complex than that.
If I could just clarify, the contract doesn't mention interest.
Correct.
Right. So, I mean, the contract and policy is all about getting benefits, correct?
Correct.
Okay, so in my mind, what I'm struggling with is I think the legislature clearly would say you're entitled to fees and interest and so forth when you get a benefit, but I don't see any clear indication that the legislature intended to provide for recovery of attorney's fees to litigate this minuscule amount of interest.
I agree. I don't think that the legislature did
I
intend.
mean, if the legislature were watching today and said, there's the fifth DCA, and they're arguing over a case involving $1.48 worth of interest, and there's tens of thousands of dollars of attorney's fees on it, I'm struggling to think that that's what the legislature really envisioned. And on the flip side of the coin is, well, 627, 428 says what it says, and we're going to strictly apply it, and if it's a judgment, then it doesn't matter what it's for. If it rises out of the litigation, tough luck, you have to pay an attorney's fee. So I'm struggling with that purpose versus strict literal application of the statute. Maybe you could help me.
Well, I think they can be harmonized. The strict construction would require the court to determine whether or not the recovery was had under a policy of insurance. And if it is not, and it clearly was not here because interest is not contemplated in the policy, it's solely a matter of statute, then under strict construction, it's not recoverable. So as the court said in the Liberty versus Pan Am, this is really something that the legislature could not possibly have contemplated and undoubtedly would not want to happen.
But that's looking behind the statute. If we're supposed to read the statute, if it's clear and unambiguous, and I don't see any ambiguity in any dispute, that language to me is about as broad. I mean, I guess you could say any and every. I don't know that adds anything, but not that I think it's a wise policy decision, but in terms of the clear language of the statute, it says any dispute, and even if you look back at 428, it says under the policy. It doesn't say and receives benefits under the policy, does it?
Well, that's correct, but I don't think that it's necessarily about benefits or not benefits. It's what's recoverable under the policy. In some instances, it could be a defense, for example. That's something, a dispute under the policy. But the bottom line is that there's no language in either of those statutes that would warrant an attorney's fee award for statutory interest, postage, or penalties. And if the legislature had wanted to include that, it absolutely could have included it. It could.
If they wanted to exclude it, they could have, and they didn't.
Well, that's correct, but there's a lot of things they didn't exclude under either of those statutes.
When it comes to attorney's fees, they did create a safe harbor. They did exclude it. If you paid it late and paid the claim, even if you didn't pay the postage, the penalty, or the interest, if you'd paid the $168 within the 30 days after receipt of the demand letter, you'd be bulletproof. You couldn't be sued for attorney's fees. The legislature could have expanded that. The legislature could have chosen to use words other than any dispute, but that's what we're left with. Again, I just don't see the ambiguity. But
Well, I mean, yeah, there's nothing recoverable under 627-736 without reference to 627-428.
Right, and 428 doesn't require a payment of benefits. It just says it has to be under a policy.
Under a policy, and if this,
Again, the trial judge could have got it wrong.
well, that bottom line is it's not under a policy. All of the cases so far that have dealt with this, and they have been out of the 4th District Court of Appeal, have not had any problem reaching the conclusion that the statute has to be narrowly construed, strictly construed, and under a contract of insurance means what it says. And since interest is not under a contract of insurance, it is not recoverable. And I think that the 4th District got it absolutely correct in its line of cases. There's no policy, there's no public policy to be served here.
Well, it does. Because you didn't pay the benefit, the $168 in time, you did go, I say you, your client, did go contrary, because the whole policy of no fault is to ensure swift, nearly automatic payment, which means 30 days from when it's submitted, or at worst 30 days after the demand letter. That's what swift payment is defined as, and your client didn't make swift payment. So it does encourage swift payment I think it's maybe draconian, it may be unreasonable, but it does serve that purpose here, doesn't it?
That's correct. And if they had sued us on day 32, we probably wouldn't be here right now, but they didn't. And at the time that they sued us, we owed them $1.48. And I submit that the trial judge was clearly correct in reaching the conclusion that attorney's fees under these circumstances are not recoverable. Thank you.
Thank you.
Well, let me ask you a couple questions. I take it from your initial argument that you view the Liberty case as both distinguishable and incorrect.
That is correct, Your Honor.
Okay. On the distinguishable fact, one thing you've argued, heard argument about is the law of the case aspect. That is the language in the original judgment.
Yes, Your Honor.
Okay. What other facts are distinguishable? And the reason I'm asking this is if facts are distinguishable, then, if we rule your way, we're not in conflict with the Fourth necessarily. But if the relevant material facts are not distinguishable, then we would be in conflict. So besides the law of the case aspect of it, with the language in the trial court's original judgment, what are the other distinctions that you're arguing to the court?
The other distinctions that separate this case from the Liberty case is, in that case, if my memory serves me correctly, the provider did not serve a demand letter. They just filed suit. And as the concurrence kind of hit on, if somebody would have just asked for the additional money, somebody with common sense would have paid. In this instance, we did do a demand letter. We did fully comply, and we did ask them, again, to pay correctly. So that, and in addition, the law of this case, the ruling in this case, because I want to hit on it, in the final judgment, the first final judgment finding that we were enforcing the terms of the policy, Judge Fields held that the interest owed on overdue PIP benefits under the insurance policy are part of the coverage afforded,
Right,
and
but
the promise of
do you
swift.
agree with me on the law of the case doctrine that language in a prior judgment has to be necessary to the opinion? And in this case, would it have been sufficient for the trial judge to have negated all that and just said under 5503, the plaintiff's entitled to $1.48?
I do think that this language was material and necessary
But
as
is
part
it-
of the analysis.
Well, would 5503 end the case on the $1.48?
Not on its own, because the question then becomes, how did you get to 5503?
Well,
And
you had the
there's two-
$168.
Well, there's two avenues to get to how to calculate the interest. One avenue is under the policy of insurance. If it doesn't specify a rate, then 687.01 directs us to 5503 on how to calculate. That's how it explains how we get there under contractual
But
analysis.
even if you didn't have that, you wouldn't even have to go to 687. If you owed if it was already agreed $160 was overdue, not paid, you could go directly to 5503 and calculate the interest, right?
Absolutely, but you have to find out how, because if there's nothing in the policy language that says this is how you calculate the interest, then the legislature gave us the tool of 687.01 to direct us on how to do that. The only other thing I would add is this court has held you don't have to obtain a PIP benefit in order for 428 to apply, specifically in Katsuma, when the insurer filed a DEC action trying to say there's material misrep, and then they ultimately extended coverage, just defense coverage. This court held that 428 applies purely under the contract, and that 428, the legislature knows how to provide exclusions. They added one just this last December by adding subparagraph 4 that it doesn't apply to residential. There's no such exclusion as set forth by what the appellee is arguing here today, or as set forth by the 4th DCA. I see my time is over, Your Honor, so I apologize.
Very interesting, well argued, thank you. And do we have our 10 o'clock folks here? All right. As soon as these fine attorneys vacate the well, you can come on up. All right, we'll now hear argument on 22-944, William Littles versus State of Florida. And you can let me know if you want 5 minutes of rebuttal time or something else.
Let's say 5.
All right, we will.
May it please the court, my name is Robert Berry. I'm the attorney for Mr. Littles. I wanted to start with language from Hine versus North Carolina, where the Chief Justice wrote for the court. The Fourth Amendment tolerates only reasonable mistakes, and those mistakes, whether of fact or law, must be objectively reasonable. And added, we do not examine the subjective understanding of the particular officer involved. And I think that last sentence is the key to this case. I address in my brief every aspect of the trial court's opinion, but I think this case ends very quickly at the objective reasonableness of the stop. And therefore, the rest of it's a fun academic law school exercise, but it really doesn't, we never reach those issues. The stop officer, and I depicted him in the photographs that I attached or included in my brief, show at the moment of truth a police car dashboard cam looking directly at my client's car, which is directly in front of him, which is directly under a green through light at a 5-lane intersection. The officer, let me actually go to the trial court's factual determination. The trial court factually determined that he did not commit a traffic violation, not the ignoring the turn signal violation, not the moving from one lane to another without indicating intention to turn, and not the failure to observe a red light.
Counsel, if I could just ask a question clarifying the facts. It's typically a 5-lane intersection, but wasn't there one, the far right lane closed? Or
No.
No, I thought there was 2 red lights and then 2 green lights.
No, and it's exhibit.
So to clarify then the far right lane is the right turn lane.
I believe it's a through or turn lane, but the video is dispositive of that not because of the stop officer's video, but I think it's C, which is the assisting officer has his dash cam light on, and that's where I actually draw some of these photographs from farther back from the intersection.
Right, I guess let me just make clear. It appears to me at least that the evidence in the case clearly establishes that there were 2 left-hand turn lanes. The officer was not in either of those. The suspect, Littles, was in front of him in the going forward lane, and they all lined up with the green go-through light. I mean, in other words, that lane went, and there's, as I understand, there's really no dispute that's the facts of the intersection and what occurred.
I hope we all agree on that.
Okay.
I recall the right of the 5 lanes, the rightmost of the 5 lanes as being an optional. In part, and here's part of the reason I think that. If you look at, and again, I think it's C, or you can actually look at it as Exhibit B. What happens is once you get through that intersection, and my client did this, he changed lanes from the lane he was in and moves to slightly to the right, because the 3 of the what I believe are 3 through lanes becomes very quickly 2 lanes after you get through the intersection.
His lane had to merge into the center.
Right. And I think it's a 2-lane, and then he starts to make his turn into the Wawa, indicating both times his intention to moved to the right, and then
Counsel, is there anything in the record that indicates what the officer's intention was? I mean, the officer was going to the Wawa. He wanted to have some coffee. So he was on his way to the Wawa, and you can do two things. You can either turn left there at that light and turn right into the Wawa,
Correct.
or you can go straight, and it goes to the back of the Wawa, and then you can turn in from there, which I believe...
And in fact, the assisting officer did the first of the ones you mentioned. He just went to the turn signal and took a...
Right, so I mean, it seemed to me it would be odd for the officer, if he's going to the Wawa, if that was his original intent, that he would do anything other than turn left. But instead he would just follow in the car in front of him.
I don't want to try to read your mind as far as the question. I don't think anybody is arguing this has ever alleged this was a pretextual stop for some other reason. I don't, you are correct, and that's how Deputy Giusino, I think, indicated the normal way would be simply to take the turn signal. But he parks behind, and I guess if you take, let me think this through.
Well, he testified he knew the area well, he'd been on patrol there before, he goes to the Wawa for coffee. I don't know if the record reflects if that's just the first time he was going to the Wawa, or whether this was, he knows that intersection well because he goes to the Wawa all the time. I don't know.
He says he's familiar with the intersection, and I'm, without getting, I don't think this has any effect on objective reasonableness, but if he is of the mind that he was in one of the two left-hand turn lanes, then he was doing what he normally would have done, and what the other officer did in going to the Wawa is take the intersection turn. He believes, his testimony was that he was behind my client, believed my client was in the turn lane, so from his perspective, which is, as Chief Justice Roberts says, is not relevant to this inquiry, feels as if my client is in the turn lane and is ignoring the turn light and then is running the red light, then he is in the lane he believes he should be in, he being Giusino, the stop officer, to make the left-hand turn to go to Wawa the way that he indicates he thought was normal for him.
If the record evidence in this case showed that the light was, let's say the infraction was allegedly running a red light, but the camera video shows that it was actually green or amber, but the officer says, no, he clearly ran the red light. But the video evidence shows, well, no, he didn't run the red light. The subjective view doesn't matter. Would you then argue, I guess you'd argue that the objectively reasonable officer couldn't conclude that there was a violation because the camera clearly showed that it was not a red light.
I'm sorry to cut you off.
I'm trying to come up with an example.
You can come up with a myriad of examples. That would be another example. I think in my brief, the state cited Willoughby and window tint cases, and if we had a daytime stop, for example, and for alleged violation of window tinting, and you could look at the vehicle and see through the body cam, there's no tinting. This is a 1967 vehicle before they ever conceived of window tinting, and there's none. Then, while we can agree that window tinting, what degree it's tinted, et cetera, whether it violates a statute, is a valid reason for stop. If there's no window tinting at all, then it's subjectively unreasonable for an officer to say, I'm stopping him because of window tinting.
Which lane somebody's in is not a judgment call, at least not in this case. It wasn't like he was straddling a lane, was it?
No. He was, I was thinking last night of if I had a second grader write down the numbers 1, 2, 3, 4, 5 and said, what's the middle number of that series of numbers? And the child said 2, or an adult police officer said 2. They're objectively unreasonable. There's really nothing, as much as I try to complicate this case with all these other arguments, even the trial judge admitted, we're only getting to those arguments because I found the stop was objectively reasonable, and it's not.
Where was the construction? It looked like the construction was on the other side where the merge was. I mean, I understand the officer said it was a confusing intersection and so forth, or at least that was the argument being made. I'm trying to figure out where the actual construction was and why it might have caused confusion, because it didn't look like the construction was of the actual turn lanes and
Right.
or the lights.
The approach to that lane, or I'm sorry, to that intersection from the direction of my client and the stop officer and the follow-up officer, the only thing I see that indicates any evidence of construction is to the left of all of these 5 lanes are some of those orange and red barrels.
They're kind of like
In
in
the
the median
median.
area, or if that is the median, that's where you see it before
Right.
you reach the intersecting street.
Right, there's a couple of those. That's the only evidence of construction that I can see. Like I said, I think I've overcomplicated this in my head, and it's really not that hard. It's, if that's objectively reasonable, that stop in that scenario, then everything's objectively reasonable. I would ask, and I had this recollection, is it Judge Makar? Am I pronouncing your name correctly?
Makar, yes.
Makar. I recall an opinion, and I can't remember what it was about, but you included pictures of a license tag in a First District case, and I think this is a very narrow decision I'm looking for, which is this stop on these facts is not objectively reasonable. Here's a picture of why. Reversed. I think a contrary finding is dangerously broad because it really does say that everything's objectively reasonable. If someone, and here's where I think the trial court made her error, is she included the officer's insistence upon his error as being probative of, included it in that mix, and the Chief Justice says, you know, we don't do that. You look at it objectively, and you all are the objectively reasonable panel here, and you make that decision.
Well, I guess we'd have to do an analysis here saying what would an objectively reasonable officer do or understand at that time and place. And I guess you would argue that an objectively reasonable officer would know that intersection, that's his territory. He should know the light configuration. He should know those would be sort of basic assumptions we would hope every officer has about his or her zone in which they're
My argument is a little broader than that. If this was the first time that officer had ever gone to that intersection, and he's looking at, he's in the middle of 5 lanes, there's 2 to his left, 2 to his right, and there's a stoplight directly above my client's vehicle in the through lane. If it was the first time or the millionth time, it is not objectively reasonable to say, because we all drive around and we go to places we haven't been before, but we managed to figure out somehow where the turn lanes are and where the through lanes are. And so I don't think it turns on his knowledge of the layout, because at that point in time it was so clear. And the only thing I would add is, it was kind of interesting to a degree that the state at the hearing focused on construction and said it, you know, the changes made it simple, but so they're making that argument on one hand. On the other hand, they're arguing that my client's self-made videos of that intersection, because of the difference in time, some was not probative. So they were arguing, you know, it's construction, and therefore that's a real important part of the analysis. But on the other hand, when confronted with the fact that it really didn't change, the state was objecting because all of a sudden it didn't become relevant when it didn't help advance their argument. If there's any other questions, I'm happy to answer them, but I've...
One last question. In addition to the lights being in front of the lanes, you also had markers on the lanes themselves. I think the 2 left had, you know, go to the left. And
Yes, they both had arrows.
And on the pavement itself, was there markers to go straight ahead?
Yes, I'm sorry. You're asking if there's pavement indications. Yes. If you want me to find it in my
Furthest to the
brief,
left had on the pavement left turn arrows in the lanes.
yeah, if you look,
So you could check by both the markers in the pavement and the lights.
the answer is yes. I'm trying to find the spot.
That's okay. That's okay.
It shows up better on video. My exhibit on page 6 of my brief, you can see it a little bit. It shows up more clearly. It shows up more clearly in the
The car is
video.
on top of, maybe on top of the arrow, but
I'm sorry, I didn't hear the
I think on one of the exhibits in your brief, you can't see the straight ahead because the car, your client's car is on top of it, but
Right.
the video shows otherwise. Video shows it.
Yes, I think that's the assisting officer's video that you can actually see these things much more clearly.
All right, thank you.
All right, thanks a lot. I guess I have, almost 5 minutes left.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. I think the key thing here is you give great deference to the judgment of the law enforcement officer at the scene while still requiring objective reasonableness. This guy
The level of
patrolled.
deference we should give reduced somewhat because of the existence of the videos.
No, because I think the videos are confusing too. The video that shows clearly that he didn't commit these traffic offenses is the video he prepared during the day, where he's parked at that light and shows you the lane next to him. It's pretty obvious during the day. When you look at the nighttime videos, I would submit it's not super clear, especially when you look at number C in the record, which was the second officer who kind of ran that left turn lane light.
Going back to,
It looked like he was in the same lane as the defendant was in when he went straight, and then all of a sudden he's turning. When you look at that video, that was my impression of the
but
video.
going back to Judge Makar's question, if the officer gave a ticket for running red light, and there's a video, and it shows there's a green light, and the car goes, and the judge says, well, I'm going to believe the officer, even though there's a video that says to the contrary, are we required to give the same amount of deference to the trial judge in that scenario when there's a video which shows, which we can view the video as well as the trial judge?
Well, let me answer that. And there's two parts to that. We can view the video as well as the trial judge, but the trial judge had the benefit of the officer narrating what he believed was happening as they watched the video. He did that twice. We don't have that.
But the judge didn't believe the officer in that respect.
The judge found it was objectively reasonable what the officer decided.
No, there didn't have to get to that because the trial judge understood it to be a mistake.
Right, an objectively reasonable mistake.
Right, but it's two steps. I mean, the first part is the trial judge concluded, no, officer, you're wrong. Even though he testified, I'm absolutely right, I'm absolutely certain. The evidence showed he was wrong.
It showed he was wrong, yes.
Was wrong.
But it showed he was wrong, but objectively reasonable because you're looking at how he was viewing it. Even at the hearing, he still felt he was right. And you're looking at why he felt that way, how he was explaining what was out
Does
there.
stubbornness translate into objectionably reasonable? I mean, he was very stubborn, steadfast, whatever word you want to use, and I mean no disrespect to him, because he's obviously a fine officer, but you look at Exhibit A, which is the video, I believe, from his dash cam, and you see Mr. Littles cross the intersecting street, get into the merge lane, that then requires him to move to the right. I really don't see the uncertainty here, other than he was convinced, the stop officer was convinced he was in the wrong lane, but...
Well, you see that from his video, kind of starts in the middle, his video. You don't see them sitting at the red light. So we don't know if he's moving around. We don't know if that was after he had shifted over, according to the officer. We don't know what had happened before that, because it kind of starts in the middle.
Exhibit A?
Pardon me?
You talking about Exhibit A?
Exhibit A, yeah.
You
I mean,
see-
they're just kind of at that light and it's green. Versus
See
the
Mr.
officer
Littles go
said,
across,
he went straight across, yeah.
and gets into the merge lane,
And then
which
merges.
then has to merge
yes,
to the right.
I think that's very clear. But we don't know what happened before that. We don't know if he had shifted over a little bit, because we didn't see the full thing where the lights were changing as they were sitting there.
The officer didn't claim he moved from a left turn lane to the right lane.
Yes, he does. The officer said that what he believed they were in the left lane, and the reason he gave him a ticket is because he moved over and went on that green light.
I'm making a signal.
So, yeah, when the signal turned. That's why he gave him the ticket, is he perceived him changing lanes. Now, in the light of day, that was probably incorrect. Well, trial judge found it was incorrect. The question is, was objectively
Everybody
reasonable?
says it's incorrect other than him, other than the officer.
Well, it's two
Everybody
people.
who's asked, who expresses their view on it says he was wrong.
He was wrong. He shouldn't have gotten a ticket. That's not the question, because he had to be unreasonably wrong.
But it's not a judgment call what lane you're in, is it? I mean, window tint, how fast somebody's going, I mean, you know, are you driving, keeping within the lane?
That's why I cited cases that weren't just window tint. Let me go back to before I get off track here, to the red light scenario, where the officer says he ran a red light. We have video that shows the light was green. Really depends on, was the light green and then 10 seconds later it turned red? Or was it green, becoming yellow, quick yellow, and then it turned red? I think those are very different scenarios as far as how it was objectively reasonable. I also think you have to consider, where was the officer when he said he ran the red light? Was he parallel to him or perpendicular to him? Was he following him? I think the fact that the officer testified, I was turning left to go to Wawa in my regular patrol area, where these intersections are full of construction, even to the date of the hearing, 18 months later. It's one of those intersections that's never finished. It's constantly changing. I was turning left to the Wawa. The defendant was right in front of me. It surprised the officer when the defendant went straight, because the officer thought he was in a turn lane. He intended to turn left. That was his testimony. So, you know, you have to consider all of that. I mean, he was right behind him.
But we don't consider subjective view.
No, but you have to consider all of the circumstances. You consider where he was, all of the circumstances, because you defer to the opinions of the officer. The trained officer at the scene.
I raised the question earlier about, we're sitting here, we're trying to determine what is objectively reasonable.
Right.
And it seems to me that there is no clear statutory guidelines for that. There's case law and so forth. But it seems to be a reasonably objective police officer ought to, A, know the intersections, and this is a significant intersection. It isn't like a minor intersection.
Yes.
Right. Should know the configurations of those, should know basically the format of the turn lanes and the stoplights and so forth, the traffic control. That's kind of sort of basic knowledge that any objectively reasonable officer should have, correct?
Yes, but you have to consider all of the circumstances. It's 3:30 in the morning, it's dark, and that's a construction intersection where it's changing every day.
Explain to me how the construction affected this basic issue.
It's a lot more confusing when you have to figure out where a lane is, if there's barrels all over and the median is gravel.
But there's no evidence of barrels in the roadway. There's just some barrels.
But the barrels were in the median.
Yeah. So how does that change the lane configuration?
I think it makes everything more confusing. The judge found it confusing.
If the barrels had been in the left turn lanes, that might have made it confusing.
But they were right next to the left turn lanes.
Yes.
So, it's a construction area. Look, the judge
so
who had the benefit...
So every time there's a construction area, we automatically conclude that there's confusion?
I think if there's heavy construction in an area, it's going to be confusing. That's a factor to consider, yes. But it has to be objectively reasonable. I mean, we're not... The judge who had the benefit of the testimony of the officer narrating what he saw that night, how he perceived the intersection, found that it was objectively reasonable. And I think when you look at it, that's the DVD labeled C. When you watch that, and this was the second officer, so the defendant's not in there, he's traveling down that road and then he turns left. When I saw that, and again, that's my opinion, when I saw that, I was surprised he turned left. I thought he was going to go straight. So that confused me.
Well, that's because the light was green going straight, and he was wanting to get as quickly as he could to the Wawa. So I couldn't tell whether he had his lights on or not, or what was going on.
I would imagine he had maybe there was no other cars. I don't know, but he ran that red light.
Right. If his lights were on, if his patrol car lights were on, then he clearly was clearing the intersection, could do what he wanted going through there. He wasn't necessarily having to comply with the traffic laws.
But my point is, the path that he took. Look, that confused me. It confused me when all of a sudden he was turning.
Well, I would agree with you that what he did was potentially confusing.
But I'm telling you...
Because he clearly, under ordinary circumstances, would be violating the traffic laws.
Well, yeah, but that's not the confusing part. Okay. It's the confusing part was what lane he was turning from.
Did the stop officer ever admit that he was confused and wrong?
He testified that it was a confusing area. He never admitted he was wrong.
Right, so
He remains steadfast, yes.
Let me ask you this on objectively reasonable. You mentioned, we don't know what happened beforehand. So let's say the officer is not paying attention to the car in front. He's looking to the right, left, doing whatever. And then he sees the car go, and he makes the assumption that that car went from the wrong lane. And then the video shows to the contrary. Is the fact that the officer wasn't paying attention or was making an assumption rather than what he visualized, does that turn it into objectively reasonable, or when we determine objectively reasonable, do we assume that it's an officer who is looking ahead?
I think you consider where the officer was and what he was doing. So in the red light example, I think it makes a difference if the officer's traveling behind the defendant and the light turned shortly after versus an officer perpendicular at the signal and the light turned 20 seconds later. I think all of those are factors to consider. So I think the fact that this officer intended to turn left and was right behind the defendant, I think that's something you have to consider, whether or not it was objectively reasonable when he gave him a ticket because the guy went in a direction that was unexpected to him.
Right, but
So two wrongs make a right?
Objective reasonableness considers all the circumstances.
Right, but does objectively reasonable assume an officer paying attention to what's in front of them, or does it include someone who misses the event and makes an assumption?
I think the fact that this officer was paying attention to what the defendant was doing for so long makes this more reasonable.
Well, it
Because
could
he
go-
wasn't just looking around and all of a sudden got surprised. He was paying attention to what was
It
going
seems
on.
like, at that point, it seems like it would cut the other way, which is that he's been following him since that mobile home park he turned out of, and he would have seen clearly what lane the defendant, Mr. Littles, was going into.
I think if this had taken place during the daytime, we would have a tough argument to say that that was reasonable. But it's the middle of the night, it's dark, there's a bunch of lights, and there's a bunch of constructions, and this intersection changes all the time. I think all of those are the factors that make this objectively reasonable. And the whole point of this subjective reasonableness is officers make mistakes. I mean, they're not perfect. This was a mistake. The trial judge found it was. We're not contesting that. It was a mistake. But the question is, the Fourth Amendment doesn't require officers to be perfect. It requires them to act reasonably. And when you consider all of the factors here, and the judge looked at all of these videos, had the benefit of the narration from both of the officers who went through that intersection, so he could really see what they were looking at and how they viewed it. And he found that it was objectively reasonable, or she, I'm sorry.
If the officer thought he was going the wrong way on a one-way street and it really was a two-way street, that's not objectively reasonable, is it?
It depends on the circumstances. If it's the middle of the night and those wrong way signs were pointing at him, that would make a difference versus during the day and it's obvious that there was nothing wrong with it. That's, when you look at these window tint cases, if it's a perfectly clear window, that's a lot different from, well, it's kind of borderline. I would submit this is one of those situations where it's borderline just because of the nature of that intersection and the construction around there.
The trial judge didn't find it borderline.
The trial judge found it borderline in the sense that it was reasonable.
Not borderline in the sense of how dark is the tent or how quick did the light change or anything else. It was clearly he was in the straight lane.
I'm using borderline in the context of if the tint is borderline, that's going to be reasonable to pull them over versus when it's a crystal clear window.
Just like eyeballing speed's a judgment call or many other things, but
Right.
what lane you're in when you're fully in the lane.
In the dark, in a construction area with a bunch of signals, and the officer believed himself to be in the turn lane. It's not like he was flying by and saw, driving by at a high speed and saw the defendant and said, oh, that was not a good lane change. He was parked behind him the whole time. I think considering all of those circumstances, and again, the narration by the deputy who was there, who explained why he believed what he believed, I think all of those circumstances support the trial court's finding that this was reasonable. If the court has no other questions, thank you.
The argument you just heard is advocating for rejection of the Chief Justice's language that I cited at the beginning of my discussion with you all in Hine. The argument is that the officer is very stubborn, and he really believes that, despite all evidence to the contrary.
If I can interrupt, we don't put any weight on what this officer subjectively thought. We may put, and the trial court should put weight on the facts that were stated, perhaps. But the conclusion that I didn't do anything, I mean, I was absolutely certain this was, that we don't put that on the scale, do we? The subjective view, the subjective view of the officer? We don't put that on the scale, so to speak.
Correct.
Right.
That's what the Chief Justice wrote.
It's the evidence that shows there's barrels on the median, that there's, the counsel said that this intersection is constantly changing. I guess the configuration of the lanes is there evidence in the record that supports that?
I don't see it. And in fact, again, the state at the trial court level objected to videos of other periods of time, including some made by my client. And I think an investigator for the defense counsel, the court ruled it was irrelevant because it was too far distant in time. Regardless, it's not unclear that night. That intersection is pretty easy to read unless you're invested in misinterpreting what's going on at that intersection.
But you would agree if that intersection was constantly evolving, every week there was some sort of different lane change and different lighting pattern, that would be a very significant factor, right?
Not in an objectively reasonable analysis, because it only matters what it looked like at that particular moment in time. The state argued against it at the trial court level. I understand they're arguing for it now at the appellate court level, but this intersection is quite clear. And the fact that there was construction 6 weeks earlier, that they had barrels blocking turn lanes, or those machines that have the messages with the arrows, turn left in 1 mile because right lane is going to be under construction. None of that's going on here. This is just a drive down a regular road approaching an intersection that goes, you start on 2 lanes and then it widens out to the 2 turn lanes, at least 2, possibly 3 through lanes, with an option to turn right on the right hand of those 5 lanes. There's just nothing confusing about this. Any other questions?
No, thank you.
I appreciate your time. Thank you.
We will be in recess. That's the Orr finger button.